rise. The Court of Appeal, Division 1, is now in session.
Good morning. Please be seated. This is the time and date set for oral argument in cause number CV18-0765, Wing versus U-Haul. These proceedings are being video and audio recorded as well as live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if you desire. Also, we have read the briefs, conferenced the case, are familiar with the facts. Please take that into consideration during your presentation. At this point, counsel, we are ready if you are.
Good morning, Your Honors. May it please the Court. My name is John Kiefer. I represent the plaintiffs, appellants Joshua Wing and his son Clayton Wing. With me today is my co-counsel, Reed Gary. We've raised 3 issues on appeal. I'll do my best to address each of them, although I'll be happy to go wherever your questions may take me. The first issue on appeal is that the trial court erred by allowing the jury to consider whether or not U-Haul had an excuse for the trial court's prior finding that U-Haul had violated the Arizona trailer brake statute. Our primary contention at trial was that the accident that rendered Joshua Wing a paraplegic would not have happened if this particular type of trailer called a tow dolly was outfitted with brakes, as Arizona law requires. After briefing and cross motions for partial summary judgment, the trial court agreed with us. The trial court entered partial summary judgment on our claim under the Arizona brake statute, and then ultimately at trial, the court gave a negligence per se instruction. However, the instruction that the court gave included language allowing U-Haul to present evidence that it had an excuse and thereby allowed the jury to excuse U-Haul's violation of statute. It's our contention that was an error of law that was prejudicial for several reasons. First of all, had the court given the proper instruction, the instruction that we, the plaintiffs, tendered that did not have the excuse language in it, the sole issue for the jury on that claim would have been causation. The jury would not have been in a position to essentially let the defendant off the hook. Second, by allowing the instruction with the excuse language, U-Haul was permitted to introduce a mountain of evidence going to its supposed, I'll use the word innocence, even though this was a civil case. First, U-Haul argued that the crux of U-Haul's argument was we were aware of this statute. We weren't ignorant of the existence of the law. Rather, we never thought it applied to us. And U-Haul was allowed to present all sorts of evidence, and its attorneys make all sorts of arguments that it had never been told by any law enforcement authority, by any regulatory body, by any court, that this particular Arizona brake statute applied to its tow dollies. In fact, at one point, counsel remarked, this court, meaning the trial court in our case, is the first court in essentially 40 years to read the statute this way. In so doing, basically inviting the jury to ignore the court's finding that U-Haul had violated Arizona law by failing to have brakes on this trailer, and in effect, inviting the jury to sort of function as a court of appeals and decide that the trial court got that issue of law wrong. The second thing that, or I guess the third thing that allowing this excuse instruction did was U-Haul seized on that mid-trial to start arguing evidence about its own post-accident conduct. Nowhere in any disclosure statement, in any pretrial statement or pretrial order, was there any suggestion from U-Haul that it was going to argue at trial that since receiving the trial court's adverse summary judgment ruling, it had essentially started to try to get its house in order. But at trial, that theme started to unfold.
Were there timely objections to this evidence of post-accident conduct?
There were to most, Your Honor.
To
Yes,
most?
I believe there were.
Well,
But
counsel, wasn't, I'm trying to remember now, was a claim for punitive damages in this case, wasn't
there was.
there? And does that evidence of post-accident procedures or attempts, does that have any relevance as it relates to a possible punitive damage claim, mitigation, or otherwise?
We would argue no. I mean, U-Haul, I will say U-Haul, and this will take me into the second issue here in a moment, U-Haul's conduct before the legislature, but U-Haul argued quite strenuously that nothing about post-accident conduct should be admitted into evidence, and it succeeded in that motion. Then mid-trial, it started presenting witness testimony that it had this project ongoing to see if it could outfit its tow dolly trailers with brakes. Mr. Schoen, the chairman, said he got reports on a weekly basis. It had been ongoing for something like 9 months. Our belief is that if the court had not essentially sort of opened up this Pandora's box by allowing this excuse language in the instruction, none of that would have been appropriate.
It's hard to see how the post-accident conduct could support circumstances of excuse, which necessity would have to be before the accident.
I'm sorry?
Well, it seems to me that the whole excuse
Right.
sort of concept deals with conditions that existed up to the point of the accident, not afterwards.
One would think so. Another reason why we don't think any of that evidence was proper. Boiling it down, U-Haul's argument, and I think they framed it, certainly in closing, I don't think there was any mistake about it, was that they were not ignorant of the existence of this brake statute. Rather, they were ignorant or did not understand the scope and the application of the statute. Our research has failed to uncover any Arizona case where a negligence per se instruction, including that sort of excuse language, was ever permitted on those sorts of facts or given that dynamic. And we make the point in our papers that, by analogy, a criminal defendant would likely not have much success trying to persuade a court that although he or she knew about a particular law, he or she didn't understand the law applied to them. We cite the State v. Saltero case, which I'm paraphrasing, but basically says the law presumes that the citizenry has all information necessary to understand the existence and the application of the law. Segueing to the second issue, this is U-Haul's conduct before the Arizona legislature. We have briefed that extensively in our opening brief at pages 20 to 25. We have a lot of detail about the comments at the legislature, how U-Haul represented to the legislators, what it was attempting to do, that it was just looking for a technical fix here. I won't repeat all that in the interest of time. I'll try my best to paraphrase it, but U-Haul was asked quite clearly. The words full disclosure was used by one of those legislators, just so there's full disclosure. Why are you doing this? Is there any issue that we ought to know about? Are you trying to legislate your way out of a problem, essentially? And the answer consistently was no. This is just a technical fix that we discovered in kind of a routine review of statutes, etc. At a later hearing, Representative Cook made the record quite clear. He said, I want to make sure we're not trying to litigate anything. And he said, the question we asked, was there any lawsuit or pending lawsuit from anything dealing with these dollies, etc.? And he said, we asked all the questions, and they all said no. At yet another hearing, only 11 days after the trial court entered partial summary judgment against U-Haul on this issue, U-Haul's lobbyist, Mr. McDonald, was back in front of the legislature, again being asked, why are you doing this? What do you hope to accomplish? And he again basically said it's a technical fix. We want to make sure this doesn't get misunderstood or misinterpreted going forward. At no point did anybody on behalf of U-Haul tell the legislature there was an accident involving one of these products A young man was permanently paralyzed. There's a lawsuit pending across town, and in fact, that judge just ruled against us as a matter of law that these trailers needed to have brakes. Now, let me pause and say there would be nothing wrong with U-Haul going before the legislature, even in the face of an adverse summary judgment ruling, and asking the legislature to change the law if it was honest and transparent, and if it answered honestly and transparently the questions that it was asked.
But counsel, the public record speaks for itself. I mean, but assume the worst. Assume the dishonesty that you're suggesting there. Why is that relevant? Why is that relevant to pre-accident conduct?
Well, it is relevant, Your Honor, because, as I say, U-Haul succeeded in persuading the trial judge to exclude all of this lobbying evidence as post-accident conduct. Then at the trial, it started to introduce its own post-accident conduct, for lack of a better phrase, wrapping itself in the flag and saying, you know, we're trying our darndest to be a good company, the chairman of the company. And by the way, as I say, this never came up in discovery. There wasn't a single document to evidence it. But nevertheless, chairman's testimony was, we've been hard at it for the last 9 months since we got the trial court's ruling to essentially try to conform our equipment to the law. In other words, U-Haul got to tell its own story about its own supposed post-accident conduct, while plaintiffs were not entitled to present this. We think a jury, given the fact that U-Haul opened the door to the issue of its post-accident conduct, we think it was absolutely fair game for us to be able to present to a jury the fact that they went in, they tried to get the law changed, and they weren't honest about it. At trial, the things they said to the court and jury were, we didn't know, we didn't understand, no one's ever interpreted the law this way. This is the first court in 40 years to do so. They certainly could have told the legislature that. They could have said this judge across town got it all wrong. This is going to create all sorts of problems. Amend the statute. That's not what they did. They surreptitiously sought to amend the statute to redefine a tow dolly in a way that would eliminate the need to put brakes on those devices going forward, when they were telling the jury in our trial, we're trying to comply with the law. We're trying to put brakes on these devices going forward. So
is it your position then that this error, you're asserting this evidentiary error, that this would impact more than just the negligence per se count, or just you're asking for? Tell me what you're asking. What relief are you asking for specifically with regard to this evidentiary error?
Well, let me say this. So we've got 3 issues on appeal, all right? If this court were to rule against us on the first issue, but rule in favor of us on the second issue, so basically send the case back for a retrial with the same negligence per se instruction that was given the first time, then the relief we would ask for is that we be entitled to present to the jury this evidence of U-Haul's misrepresentations before the legislature.
Across all counts, across all the counts, not just the negligence per se count.
You mean
product liability count as well? Would that be on the table in remand?
Would this evidence be on the table as it relates to the strict liability count?
Yeah, sorry, the strict liability. Would that still be? Would that be you're asking to retry that count?
I don't know that I've thought of it in great depth. I think by the inherent nature of strict liability, we typically are not engaging in an inquiry about the reasonableness of conduct. And so I don't see it as applicable to strict liability. I guess I would say, kind of speaking off the cuff, I'd be happy to talk to the trial judge about that and either entertain a limiting instruction that evidence did not apply to the strict liability count, or to discuss whether we would even proceed forward on the strict liability count. But to try to complete my answer to your question, so if this court ruled against us on the instruction issue and we retried the case with the same instruction, we think we absolutely should be entitled to present evidence of U-Haul's misrepresentations to the legislature, because they have and presumably would again talk about their post-accident conduct as being reasonable. On the other hand, should the court give us relief on the first count and send the case back for trial with what we believe is a proper negligence per se instruction that does not contain the excuse language, then I think it would be an open question to discuss with the trial court as to whether, in fact, that evidence of U-Haul's post-accident conduct before the legislature would, in fact, be proper and relevant.
And would it be appropriate for us, if we were to decide in your favor on the jury instruction question, why would we need to reach issues 2 and 3? Do you have an opinion on that?
Well, I think as to issue 2, I'm not sure you'd have to reach an opinion as to issue 2 if you find in our favor on the jury instruction issue. As to issue 3, that is essentially a separate issue. We think it's pretty serious, a pretty egregious behavior and pretty egregious, respectively, error by the trial court, and it's not expressly linked to the first issue. Now, I would hope that with the benefit of hindsight, defense counsel would not make statements, for example, in closing argument, commenting about the absence of evidence of other lawsuits when that had been excluded pre-trial, and we never opened the door to that. And I would hope perhaps the court would reach a different ruling, mindful of the fact that, when it arose the first time in closing, without warning, we objected in open court with the jury present, and the judge ruled on the spot. Seeing, where the issue has gone and the briefing and whatnot, I would hope that the trial court would issue a pretty strong admonition to counsel that that is improper and that subject is not to be addressed in evidence or in argument. That was a long-winded response to a simple question. I apologize, but I don't think that third issue is necessarily linked to the instruction issue. And let me see. One thing I might briefly address, and then I'll reserve whatever time remains. On the instruction issue, U-Haul's argument is essentially, one of their arguments is essentially that because the jury found against us on the strict liability claim, then necessarily there was no harm, no foul, no prejudice. We think they're wrong. First of all, they make an argument that the jury must have found there was no causal connection between the absence of brakes and the accident. But this was not a special verdict. It was a general verdict, and the jury made no such finding that was recorded in the evidence. As it relates to, I guess I want to make one distinction that I think is important, clear. The design defect claim under the strict liability instruction is essentially a risk benefit or a risk utility test that requires the jury to weigh the pros and cons of the particular design. U-Haul introduced evidence that it claimed this trailer met industry standards and performed just fine in terms of braking and stopping even without brakes. We disagreed with that evidence. We had responses to it. But if the jury believed that evidence and accepted it, then it could have found in favor of the defendants on strict liability before it ever reached the question of causation. Additionally, because of the erroneous excuse language in the negligence per se instruction, the jury very easily could have discounted or disregarded what we believe to be a very pertinent negative in that risk utility balancing test, namely, trailer's not legal to operate on the roadways of Arizona for want of brakes. But be that as it may, given the way the case was submitted to the jury very certainly could have found that they could have accepted U-Haul's evidence, found that the trailer was not defective, never reached the question of causation. On the negligence per se issue, had the court given the instruction that we tendered, the jury would have had the obligation to address only causation under the negligence per se instruction. But because the court included the improper excuse language, again, the jury could have, for lack of a better word, accepted U-Haul's excuse and never reached the question of causation under either theory. The Salt River v. Westinghouse case that we cite in our papers indicates that if there's any chance, essentially, that an erroneous instruction prejudiced the result, then it requires a new trial, even if the jury possibly could have found for the prevailing party under some other theory. We submit that's exactly the case here. I'm going to reserve the balance of my time, what's left of it, for rebuttal. Thank you.
Thank you, counsel.
Good morning.
Morning.
May it please the court, my name is Travis Wheeler. I represent the defendants Appalese U-Haul International, Inc. and U-Haul Company of Oregon. Plaintiffs got a fair trial. Judge Campagnolo presided over a well-run, hard-fought, complex trial that saw 24 witnesses in 12 days. And during those 12 days, plaintiffs elicited substantial, detailed testimony about the design of U-Haul tow dollies, about the history of those tow dollies. And I want to make one point here. The evidence of U-Haul's design of its product and its understanding of applicable statutes and regulations, including the Arizona trailer brake statute, this evidence was coming in anyway, regardless of the negligence per se instruction, as a part of plaintiff's negligence claim, product liability claim, and punitive damages claim, as pointed out. At no point was there any objection to this evidence coming in or any indication by the trial court that evidence was coming in solely because of the negligence per se instruction. Relatedly, the evidence of U-Haul's post-ruling conduct, its investigation of brakes, that also cannot be traced to the negligence per se instruction, as counsel suggests. That evidence was actually elicited by plaintiff's counsel in the questioning of a U-Haul witness, asking, what had U-Haul done since learning of Judge Hanna's ruling? And U-Haul's counsel objected to that question as being irrelevant. That testimony was brought into the case by plaintiff's counsel, and then there was some follow-up on that from U-Haul's counsel. During this 12-day trial, because of the pretrial ruling, plaintiffs repeatedly referred to the subject tow dolly as the illegal tow dolly. U-Haul's defense was that Joshua Ring's unfortunate crash and injuries were the result of the reckless driving of Matthew Del Colo, who was making an unsafe passing maneuver at a speed too fast for conditions, as DPS concluded, and that this crash had nothing to do with lack of brakes on the tow dolly, and that brakes actually wouldn't even help during a sway event like the one Mr. Del Colo experienced. Plaintiffs requested a general verdict, and they got a general verdict for the defense. There was more than sufficient evidence for the jury to base that general verdict on plaintiffs' failure to prove causation, and plaintiffs have shown no basis to overturn that or prejudice from their issues on appeal. Specifically with respect to the instructional issue, plaintiffs here are contending that there was a single line in a single instruction that shouldn't have been there, and that this single line somehow caused the jury to excuse a violation of the law due to ignorance of the law. But the instruction specifically says ignorance of the law is not an excuse for violation of the law.
What exactly was the legal excuse and the evidence of that to support that instruction?
Well, first of all, Your Honor, plaintiffs did not move for a new trial and ask Judge Campagnolo to identify what evidence supported this instruction, which was clearly stated in the O'Donnell case. Evidence that could support the instruction would include generally evidence that U-Haul exercised reasonable diligence and care in attempting to comply with the law. First of all, this tow dolly was rented in Oregon, not in Arizona. Oregon, where tow dolly brakes are not required. Second, when this tow dolly was rented, the trial evidence was no regulator, no enforcement agency, no court had ever construed the trailer brake statute in Arizona to apply to tow dollies, and neither had the industry. Third, U-Haul exercised reasonable care in designing its tow dollies, and the tow dolly met the performance requirements of all recognized industry standards and the stopping distance requirement of the Arizona trailer brake statute without brakes. And finally, U-Haul not only believes that tow dollies were not required and not necessary, but they actually presented safety-related problems. Plaintiffs point out that there was a time when U-Haul had brakes on tow dollies, and there were problems with those. There were fires with those and other wear problems with those. Brakes didn't work on tow dollies. And as I alluded to earlier, brakes wouldn't help in this situation at all, which was a trailer tow dolly sway situation where U-Haul expressly advises against applying brakes. Judge Campagnola wasn't asked to identify what evidence supported the instruction, but there's plenty of evidence in the record to support it, particularly given that this court must review the record in the light most strongly to support the giving of the instruction and affirm if there's any conceivable evidence within the flexible doctrine of negligence per se to permit this instruction. Even if there were any error, plaintiffs have not shown prejudice. Again, there's no risk that the jury was misled by this instruction. The instruction specifically says that ignorance of the law is not a defense for violation of the law. Again, plaintiffs are challenging the sufficiency of the evidence to support the instruction, but there was more than sufficient evidence to support the jury's verdict on the basis of no causation, and that alone is basis to affirm the verdict. There's, counsel pointed out how there was a general verdict. That was plaintiff's choice to pursue this case on a general verdict. U-Haul actually proposed special interrogatories. Plaintiff objected to those, wanted a general verdict, and so to the extent that they can't point to the verdict for prejudice on this instructional issue, that's of their own doing.
Let's go back and talk about the evidence U-Haul presented that it attempted to comply with ARS 28952 but were unable to do so. What evidence was presented specifically on that point?
Well, the way I phrased it, Your Honor, was that U-Haul made reasonable efforts in an attempt to comply with the law. U-Haul understood, U-Haul was aware of the existence of the statute, understood that it applied to trailers. U-Haul put brakes on trailers. U-Haul did not understand that the tow dolly was covered by that statute.
So didn't you just say U-Haul did not understand that a tow dolly was covered, which I get the trial court decided that it did apply to tow dollies, and that was the first time that it happened but given the fact that it did in this case apply to tow dollies, isn't all the evidence that you have just pointed to ignorance of the fact that it does apply to tow dollies?
And not the fact that the tow dolly was rented in Oregon. Plaintiffs claim in their brief that U-Haul knew that this particular tow dolly would be in Arizona, but they have no citation for that in the record. This was a U-Haul tow dolly rented in Oregon to a Texas resident in Oregon. That was the context of the rental of the tow dolly.
Where was he to return the tow dolly?
In Texas.
And how do we get from Oregon to Texas, skirting Arizona?
You can do it, Your Honor.
All right. Probably not the fastest route, though.
U-Haul had placed brakes on tow dollies in the past, determined that tow dollies were not only, as it believed, not required and not necessary, but actually presented safety-related problems due to the specific design characteristics of tow dollies.
And I understand that testimony, and I understand what you're saying. What I'm saying is that once the court made the determination that this statute applies to tow dollies in the state of Arizona, the only evidence presented was evidence that U-Haul didn't think it did. U-Haul didn't think it should. Nothing says U-Haul tried to comply with this statute and was unable.
or that U-Haul didn't know the tow dolly was going to be in Arizona. That's different than not knowing that the tow dolly, that the trailer statute applied.
Wait a second. U-Haul has to assume, I believe, that its equipment is going to be used in every state. Are you saying there's some sort of special exception?
I'm just saying for the
by state basis.
I'm just saying that in this case, Your Honor, we have a product that starts out in Oregon. It's traveling through a number of states, many of which do not require brakes on tow dollies. That's my only point, including Oregon.
So if U-Haul, at the time of the rental, had said, we're going to rent you this tow dolly, and was aware that Arizona required brakes on tow dollies. You're not allowed to drive it in Arizona to get to Texas, but you can use this tow dolly. That would have been, they didn't do that, did they?
No, Your Honor. Look, this is not a, I understand, I believe that U-Haul articulated a reasonable diligence in attempting to comply with the law that is different from ignorance of the law. But even if I'm wrong about that, the jury was instructed that ignorance of the law is no defense. There was no objection to argument made in closing argument by U-Haul's counsel in trying to discuss the no-fault language in the jury instruction. The jury was clearly instructed that ignorance of the law is no defense. Furthermore, there's no prejudice here because plaintiffs were not entitled to this instruction in the first place. The application of the tow dolly, of the brake statute to the tow dolly was obviously closely litigated. We believe, for the reasons I've explained in the briefing, that the trailer brake statute does not and never has applied to tow dollies and therefore should not have been on the table for a negligence per se instruction. And furthermore, even once the decision was made by Judge Hanna that the statute applies to tow dollies, there was still a further determination to be made as to whether it needed to be used or should be used for negligence per se. This case was not a prosecution for violation of 28-952. This was a negligence claim, and negligence per se is a doctrine where there is discretion in the court to take a criminal or quasi-criminal statute that the legislature has not specifically said should be used in a negligence case and import that into a particular negligence case. And here, given the conflicting state laws, given the lack of clarity as to the meaning of the statute and the lack of notice that it applied to tow dollies, and given the fact that plaintiffs already had a product liability claim going alongside, it's our position that there should not have been, the statute should not have been used for negligence per se instruction at all. And in order to reverse this verdict, this court would have to undertake this statutory analysis and determine that Judge Hanna was right in his ruling and determine that there should have been an instruction given, and determine that Judge Campagnolo's inclusion of language in the instruction that comes directly out of Arizona Supreme Court precedent was not supported by any evidence in the record, even though plaintiffs failed to move for new trial and question that, and then determine that there is prejudice from that, even though plaintiffs lost on their product liability count, and even though plaintiffs never asked for special verdict interrogatories to show that the jury reached its finding based on negligence, and there is sufficient evidence in the record to support the finding based on no causation. And even though the major prejudice they're claiming, that the jury somehow believed ignorance of the law is a defense, is explicitly stated in the instruction that ignorance of the law is not an excuse to violation of the law. I think for all of those reasons, this first issue fails for multiple different grounds. With respect to the remaining issues, the lobbying evidence, as I think this court can see, has nothing to do with this case. The 2018 lobbying efforts of U-Haul have nothing to do with this case concerning a 2014 crash. And plaintiffs' creative attempts to try to bring in some relevance here simply doesn't work. And
Real quick.
Yep.
Subsequent remedial measures, not admissible, but they came in this case. What is since this accident, what is U-Haul doing? What studies, et cetera, Shouldn't they also have been able, if you were going to be able to get into that kind of evidence, which shouldn't have come in, I would say, be able to get into other things that U-Haul was doing subsequent to this accident? I mean, why is it good for the goose if it's not good for the gander?
Well, because it was the goose and the goose, because plaintiffs' counsel asked the question of U-Haul's witness, what has U-Haul done since the ruling to, put brakes on tow dollies? That was not, and U-Haul objected to that, that seeing no relevance to post-ruling conduct by U-Haul years after the crash. So plaintiffs opened the door to that and then brought that in, and U-Haul followed up on that line of questioning subsequently. But U-Haul...
Then what right does the court have to shut the door back? I mean, and not let further evidence on that?
Absolutely, Your Honor. At some point, yes, we have to stop adding to the levels of collateral evidence here. We have some collateral evidence in the door. They think, oh, this can impeach this collateral evidence if we bring in this new evidence that I don't think is impeaching at all, because you can investigate tow dolly brakes and you can lobby the legislature at the same time.
But
so it's
they
not
give opposite inferences. One is we're going to fix this problem and we're going to comply with this law. The other is we're going to get rid of this law because we don't believe that there's a problem. I mean, both cannot be true.
Well, I think Judge Campion, as stated by Your Honor, yes, but it is certainly conceivable that you can address an issue in a multi-pronged manner, including investigating brakes and lobbying the legislature. Judge Campagnolo recognized that. And furthermore, more importantly, the evidence of the lobbying and the accusations of the lying and the deceitful conduct, hugely prejudicial, hugely confusing to the jury. This would devolve into a mini trial on this issue that is simply not relevant to the core issues in the case.
But isn't the inverse also true? Okay, so they bring up this information. You guys object. You guys clarify and get into the things that have actually been going on, the studies, etc. Leaves the jury with the impression that U-Haul is taking steps to make sure that they equip their tow dollies with brakes in the future and are going to comply with this law. And then the converse is, no, they're not. They're not doing that. What they're doing is getting the law changed to comply with their idea, U-Haul's, of whether or not this tow dolly is safe.
But Your Honor, there's just no relevance to what U-Haul is doing now to comply with the law. I mean, I think Judge Winthrop asked earlier, is that relevant to punitive damages? And I think plaintiff's counsel conceded, no, it's not. No, it's not. You don't look at just, general conduct by a defendant to determine punitive damages. Under the Salcedo case cited in our brief, punitive damages is like any other type of, tort. The conduct, the evil mind and, evil hand conduct has to injure the plaintiff. And so stuff that's happening 3-4 years later is not injuring Mr. Wing.
And I agree. So, shouldn't have come in. None of it should have come in. If we start with that premise, right? A little bit came in. Whoever got it in, a little bit came in. Somebody came and followed up on it. Why was it not allowable to allow testimony to counter an impression that is not completely consistent?
Because it's impeachment of a collateral issue, first of all. And secondly...
I don't disagree. It shouldn't have come in. That's where we start. None of it should have.
I know, but the evidence that you're saying should come in further. Okay, well, maybe we could bring in lobbying evidence to somehow impeach this original evidence about post-ruling conduct. Well, the post-ruling conduct is collateral, so you can't bring in evidence to impeach a collateral matter. And this is a discretionary decision that's reviewed extremely deferential. Judge Campagnolo is there, and he decides, as Judge Brown says, at some point you got to stop the admission of irrelevant evidence. And a good point to do it is before you get into, this lobbying evidence that is heavily loaded with 403 concerns and is going to take up time and confusion and simply has no place in the trial. With my last 14 seconds, I'll say in the final issue, there was no error in counsel's reference to plaintiff's failure to admit other incidents. Plaintiffs voluntarily chose not to introduce any of that evidence, and even if there was any error, plaintiff's rebuttal was better than any curative instruction to remove prejudice. Thank you.
Thank you, counsel.
Thank you. In the very limited time I have remaining, I want to return to the instruction issue. I think the court grasps the kernel of that issue. Judge Winthrop asked, what was the legal excuse that you all gave? And I'm not sure I heard a direct answer to that question, other than we believed our trailer was perfectly fine without brakes. Boiling it down, Judge Campbell, I think, asked the question several different times. What evidence was there that U-Haul attempted to comply with ARS 952 and was prevented from doing so? There was absolutely none. To be clear, the issue of brakes on tow dollies was not a mystery. This trial court ruling was not the first time they'd heard of it. The patent, which U-Haul got in 1969 for this device, called for brakes. They had brakes on tow dollies for a number of years. They were tested in Phoenix at the U-Haul test track in the early 80s and determined to work better with brakes, and the evidence at trial was they took the brakes off because it was costing them more than $75 to repair them. This was not a new issue that had never occurred to them before, and yet at trial, their argument... Yes, Your Honor.
I've got one thing that I really want you to answer.
Sure.
In that instruction, it says ignorance of the law is not an excuse.
Yes.
How do you address that particular point?
Because then it goes on to say, defendants have the burden of proving that their failure to equip the tow dolly with brakes was not their fault. And the way it was argued, I've talked some about the evidence, but the way it was argued was, we're not saying, and this is a paraphrase, but it's really close, we're not saying we were ignorant of the law. We knew the law was there. We just never thought it applied to us. In 40 years, this is the first time anybody's ever said it applies to us. Now, I would concede, I think that's a distinction without a difference, right? But what they're, and I'm going to end up on this, but to me, the key issue on this is whether U-Haul's supposed ignorance of the law's application versus its existence is a valid excuse under Arizona law. We don't believe it is, and we don't believe that just including one sentence saying ignorance of the law is no excuse somehow justifies or cures then putting the excuse language in, because as I say, the way counsel argued it was to say, we're not ignorant of it, we know it's there, we just didn't think it applied to us.
Thank you.
Thank you, Your Honor.
All right. Thank you both for your arguments and your hard work in this matter. We're going to take this matter under advisement. We will issue a written ruling in due course. We are adjourned.